Breaking late today, Erin Andrews and that major victory, a $55 million guilty verdict in her case against a stalker and the hotel that gave him a room next to hers. The jury siding with Andrews after emotional testimony, speaking of her humiliation and shame that followed video taken of her through a peephole seen by nearly 17 million people. ABC's Eva Pilgrim inside the courtroom when the verdict was read today.
Late today, the verdict in the Erin Andrews case.
What amount of damages, if any, do you award the plaintiff, Erin Andrews? $55 million, correct?
Yes.
The jury has decided the Nashville Marriott shares the blame for that secretly recorded naked video that was seen by more than 17 million people.
You know her body? When I saw it for 2 seconds and I was like, oh my God.
Andrews claiming the hotel made it easy for her stalker, Michael Barrett, to get a room next door to hers and through a peephole use his cell phone to shoot video of her getting out of the shower.
I called the operator and asked, could I have Erin Andrews' room? They connected me so that I knew what room she was in.
Barrett pled guilty to stalking in 2010 and served 27 months in prison. She sued him, the Nashville Marriott, and the hotel's management company, their lawyers claiming throughout the trial that Andrews' career was not harmed, but has in fact thrived since this happened.
She's not claiming her career was ruined because of this. She's saying her life was ruined because of this.
Do you believe you will ever get over this?
No.
David, stalker Michael Barrett was found to be 51% at fault, making him responsible for more than $28 million in damages, which he'll have trouble coming up with. The hotel management company and owners were found to be 49% at fault. They'll have to pay out more than $26 million. David?
And Eva, have we heard from Erin Andrews tonight?
David, yes, she tweeted thanking all of the victims out there for their support to stand up and hold accountable those whose job it is to protect everyone's safety and privacy. David?
Eva Pilgrim inside that Nashville courthouse tonight. Eva, thank you.
You may be seated.
We're doing good, Your Honor. 2.40, that instruction, we had just a small issue with. If you can get it, 2.4, do you have that? We think that, of course, the plaintiff can prevail if she proves Windsor was negligent in that fall, and she can prevail even though the jury could find that West End was not the agent, that Windsor was not the agent. So we think it's misleading in that first paragraph to say she has a burden of establishing by preponderance of the evidence. All of the facts, we'd like to strike the words all of the, so it's clear she has to prove by preponderance of the evidence facts necessary to prove the following issues. That's what we'd like it to be.
Well, Your Honor, the problem with that is that the reason that's in there and the reason it's in the instruction is because for negligence you got to prove the party's negligence, and you have to prove that they were the cause of the injuries. So that's the purpose of all of these. So it's either going to have to be, that first one's going to have to be separated from the group.
So y'all really didn't agree on this after I thought that you would?
No, we've got everything worked out. I mean, this was just brought to us, and Mr. Kennard wants me to agree that all of the elements of negligence are not required, which is incorrect. So only thing I'm saying is that if you want to take all of them, then we've got to separate West End with the principal of Windsor.
I think it's self-explanatory. I'll elucidate a little bit to the jury, make sure they get this.
So we're leaving it like it is?
Yeah.
Okay. So we good?
All right. Judge Nelson Day of the First Circuit Court, 20th Judicial District, State of Tennessee, presiding. Court is now in session. You may
Okay, good morning. As I told you yesterday, we've now reached the end of the trial, where both parties have completed their proof, and I would charge you on the law now that applies to this case. Now, before I do that, there are a couple of things we need to do. First of all, Ms. Cornelius and Ms. Newland, thank you very much for your service. However, your tenure is over because we have 12 jurors. But before you leave, you have the choice, which will be given to all the parties, in this case as well as jurors, to go out the back door and go downstairs. Number one is you can't talk about the case, even though you're off the jury now. Don't say anything until you hear the verdict. We'll call you and tell you the verdict. We have your phone numbers. But you can go out the front door or the back door and you tell me what you'd rather do. Okay. Thank you very much. As a presidential candidate would say, you're fired. Okay, those of you who are on the jury, a couple of things. First of all, the factor of delay. This is 8 years since this incident happened in 2008, and now the trial is before you. None of the parties before you can be charged with delay. In fact, the delay was on another party's fault, and that party was forced to give testimony under court order. He is not here. Which brings me to this. In Tennessee, there's a doctrine of comparative fault. You can compare the fault of two people or two entities that may or may not be at fault and come out with an end result. And that's what's before you now. You'll have to determine the fault, if any, of the defendant Windsor. You must also determine, as I'll charge you, whether West End was the principal of Windsor and Windsor was the agent. Those I'll talk to you about in a minute. But right now I'm going to direct a verdict against Mr. Barrett. He is obviously responsible for this intentional tort. All of you say yes. Nod your heads. Yes. So now your inquiry is whether or not Windsor and or West End have a responsibility in this case. Now, members of the jury, now that you've heard all the evidence and arguments of the lawyers, it is my duty to instruct you on the law that applies to this case. You will be provided with written instructions of these jury instructions. It is your duty to decide the facts from all the evidence in the case. After you determine the facts, you must apply the law that I give to you, whether you agree with it or not. You must not be influenced by any personal likes or dislikes, prejudice or sympathy. You must decide the case solely on the evidence before you and according to the law that I'll give to you. All of these instructions are equally important. The order in which they are given has no significance. You must follow all the instructions and not single out some and ignore the others. In reaching your verdict, you may consider only the evidence that was admitted. Remember that any questions, objections, statements, or arguments made by the attorneys during the trial are not evidence. If the attorneys have stipulated to or agreed to any fact, however, you will regard that fact as having been proved. That testimony that you have instructed to disregard is not evidence and must not be considered by you. If evidence has been received only for a limited purpose, you must follow that limited instruction that I had given you. You are to decide the case solely on the evidence received at this trial. Although you must consider the evidence in this case in reaching your verdict, you're not required to set aside your common knowledge. You are permitted to weigh the evidence in light of your own common sense, observations, and experience. Now, there's more than one defendant in this lawsuit. You may find that one defendant is at fault, and you're not required to return a verdict against both. You will decide each defendant's case separately. Each defendant is entitled to fair and separate considerations. Unless you're instructed on the contrary, the instruction applies to the facts of each defendant's case. Now, of course, that doesn't apply to Mr. Perry, who we have given a directed verdict against. Now, some of you have taken notes during the trial. Once you retire to the jury room, you may refer to your notes, but only to refresh your own memory of the witness's testimony. You are free to discuss the testimony of your witnesses with your fellow jurors, but each of you must rely on your own individual memory as to what that witness did or did not say. In discussing the testimony, you may not read your notes to your fellow jurors, or otherwise tell them what you have written down. You should never use your notes to persuade or influence other jurors. Your notes are not evidence. Your notes should carry no more weight than the unrecorded recollection of another juror. Now, the fact that corporations are parties must not influence you in your deliberations or in your verdict. Corporations and persons are equal in the eyes of the law, and both are entitled to the same fair and impartial treatment and to justice by the same legal standards. Now, you are to decide this case only from the evidence which was presented at this trial. The evidence consists of 1, the sworn testimony of the witnesses who have testified, both in person and by deposition. 2, the exhibits that were received and marked as evidence. And 3, any facts to which all the lawyers have agreed or stipulated to, and any other matters that have instructed you to consider as evidence. Now, what is meant by direct and circumstantial evidence? There are 2 kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as a testimony of a witness about what that witness personally observed. Circumstantial evidence is indirect evidence that gives you clues about what happened. Circumstantial evidence is proof of a fact or a group of facts that causes you to conclude that another fact exists. It is for you to decide whether the fact has been proved by circumstantial evidence. If you base your decision upon circumstantial evidence, you must be convinced that the conclusion you reach is more probable than any other explanation. For example, if a witness testified that the witness saw it raining outside, that would be direct evidence that it was in fact raining. If a witness testified that the witness saw someone enter a room wearing a raincoat covered with drops of water and carrying a wet umbrella, that would be circumstantial evidence for which you conclude that it was raining. You are to consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give any evidence. In making your decision, you must consider all the evidence in light of reason, experience, and common sense. Although you must consider all the evidence, you're not required to accept all of the evidence is true or accurate. You should not decide an issue by the simple process of counting the number of witnesses who have testified on each side. You must consider all of the evidence in the case. You may decide that the testimony of a fewer number of witnesses on one side is more or less convincing than the testimony of more witnesses on the other side. Now, what is meant by absence of witness or evidence? Under certain circumstances, you may consider the absence of evidence or a witness. You may conclude that the testimony of the witness would be adverse to the party that failed to offer it only if you find all of the following elements. One, that it was within the power of that party to produce a witness on an issue in this case, but that party has failed to produce the witness. And two, the witness was uniquely under the control of that party and could have been produced by the exercise of reasonable diligence. And three, the witness was not equally available to an adverse party, and the witness was likely to be biased against an adverse party because of a relationship to the party who would be expected to produce that witness. And four, the witness's testimony would not be merely cumulative. Five, a reasonable person under the similar and same circumstances would have produced the witness if the testimony would be favorable. And six, no reasonable excuse for the failure has been shown. You must find all these elements before you can conclude that the testimony of a witness would be adverse to that party. Now, certain testimony has been presented to you by deposition. A deposition is testimony taken under oath before the trial and preserved in writing or on videotape. You are to consider that testimony as if it had been given here in open court. Now, you're the sole judges of the credibility of the witnesses in this case. You're the sole judges of the credibility and believability of the witnesses who have testified. You must decide which witness you believe and how important you think their testimony is. You're not required to accept or reject everything a witness says. You're free to believe all, none, or any part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness, but it may help you to think about the following questions. Was the witness able to see, hear, or be aware of the things about which they testified to? How well was the witness able to recall and describe those things? How long was the witness watching or listening? Was the witness distracted in any way? Did the witness have a good memory? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did the witness have any interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence that witness's testimony? How reasonable was the witness's testimony when you consider all the evidence in the case? Was the witness's testimony contradicted by what that witness has said or done at another time, by the testimony of other witnesses, or by other evidence? Has there been any evidence regarding the witness's intelligence, respectability, or reputation for truthfulness? Has the witness's testimony been influenced by any promises, threats, or suggestions? Did the witness admit that any part of the witness's testimony was not true? Now, there may be discrepancies or differences between a witness's testimony or between the testimony of different witnesses. This does not necessarily mean that a witness should be disbelieved. Sometimes when two people observe an event, they will often see or hear it differently. Sometimes a witness may have an innocent lapse of memory. Witnesses may testify honestly, but simply may be wrong about what they thought they saw or remembered. You should consider whether a discrepancy relates to an important fact or only to an unimportant detail. You may conclude that a witness deliberately lied about a fact that is important to you and your decision in this case. If so, you may reject everything that witness has said. On the other hand, if you decide that the witness lied about some things but told the truth about others, you may accept that part you decide is true, and you may reject the rest. Now, expert testimony has been given in this case. Usually, witnesses are not permitted to testify as to opinions or conclusions. However, a witness who has scientific, technical, or other specialized knowledge, skill, experience, training, or education may be permitted to give testimony in the form of an opinion. Those witnesses are often referred to as expert witnesses. You should determine the weight that should be given to each expert's opinion and resolve the conflicts in the testimony of the different witnesses. You should consider the education, qualifications, and experience of the witnesses, the credibility of the witnesses, and the facts relied upon by the witnesses to support the opinion, the reason used by the witnesses to arrive at the opinion. You should consider each expert opinion and give it the weight, if any, you think it deserves. You're not required to accept the opinion of any expert. Now, an expert witness was asked to assume that certain facts were true and give an opinion based upon that assumption. This is called a hypothetical question. You must determine if any fact assumed by the witness has not been established by the evidence, and the effect of that omission, if any, upon the value of that opinion. Now, one of the first things, in fact, the first thing you'll have to determine in this case is the relationship between the two defendants. A principal can be responsible for the acts or omissions of the principal's agent. A person who is authorized to act for another person or in the place of another person is an agent of that person. A person may be an agent whether or not payment is received for the services. For purposes of this case, the term agent includes both a servant and employee. The person who authorizes the agent to act is called a principal. For the purpose of this case, the term principal includes an employer. Now, the agreement between the two defendants I spoke of, West End and Windsor, is a relevant factor in determining whether a party is an agent or an independent contractor. However, it is not the only relevant factor. The conduct of the parties is also relevant. Other factors to be considered are the right of West End to terminate the contracted will with Windsor, sharing in profits, right to control day-to-day activities, joint decisions in day-to-day business matters, the right to make a final decision on security matters, and any other factors which you believe are relevant. In order to be considered the act of a principal, the act of the agent must be within the scope of the agent's authority or employment. It is not necessary that a particular act or failure to act be expressly authorized by the principal to bring it within the scope of the agent's authority or employment. Conduct is within the scope of the agent's authority or employment if it occurs while the agent is engaged in the duties that the agent is authorized or employed to perform, and if the conduct relates to those duties. Conduct for the benefit of the principal that is incidental to, customarily connected with, or reasonably certain to perform an authorized act is within the scope of the agent's authority or employment. Now, the plaintiff claims that the defendant West End Hotel Partners, LLC, was a principal and that the defendant Windsor Capital Group was an agent of the principal. If you determine that the defendant Windsor Capital Group was the agent of the defendant Windsor Hotel Partners and was acting within the scope of the agent's authority at the time of the events, and you find that the defendant Windsor Capital Group should be held responsible, then the plaintiff can recover damages against both defendants. And for the purposes of your case, it will be treated as one. However, if you determine that the defendant Windsor Capital Group should be held responsible but was not the agent of the defendant West End Hotel Partners, or was not acting within the scope of the agent's authority at the time of the incident, the plaintiff cannot recover damages against West End, but they can recover damages against Windsor. Y'all understand that? In other words, you don't have to find West End Partners guilty of negligence to continue your inquiry. If you find that the defendant Windsor Capital Group should not be held responsible, then the plaintiff cannot recover damages against either defendant. Now, one of the issues which you must decide, as I said, at the time of the events is whether the defendant Windsor Capital was the agent of West End Hotel Partners, or whether Windsor Capital was an independent contractor, and you would find acting alone. While both agent and independent contractor work for another person, there's an important distinction between them. An agent of another person, called the principal, is authorized to act for or in the place of that principal. A principal has the right to control the agent's actions. A principal ordinarily is legally responsible for the acts or omissions of the principal's agent. An independent contractor exercises an independent employment or occupation in providing services. The independent contractor is answerable to the employer only as to the results of the work and not as to how the work is to be performed. A person who employs an independent contractor ordinarily is not legally responsible to others for the acts or omissions of the independent contractor. Whether one is an agent or an independent contractor depends upon who has the right to general and immediate control over the methods and manner in which the work is done. If the one who performs the work has the right, then that person is an independent contractor. If the employer has that right, then the employer is a principal and the one who performs the work is the agent. An independent contractor may consider and follow any suggestions that the employer may make. His actions do not change the independent contractor into an agent, so long as the independent contractor retains the right of control over the methods and manner in which the work is done. Now you will be given a verdict form, which should be kind of like a roadmap of how you go through this case. As I told you, the first item is to consider the relationship between Windsor and West End. If you find that West End is not responsible to Windsor, as Windsor being an independent contractor, then you go to the next question. If you can't decide that question, you still go to the next question, because Windsor is still a party to the lawsuit. You simply say we can't decide. If you decide that West End is a principal and Windsor's agent, then you go to the next question. You can consider both of them as one party, even though they may be listed separately. Do you all understand that concept? Now, I'm going to charge you on the burden of proof in this case. In this action, the plaintiff has a burden of establishing by preponderance of evidence all the facts necessary to prove the following issues: that West End was a principal of Windsor. 2, that Windsor was negligent. As I said, if you cannot decide, you still go to number 2. That Windsor was negligent. The plaintiff may recover damages from Windsor even if you find that it was not the agent of West End. 3, that the negligence was also a cause of plaintiff's injury. Then you would determine the percentage of fault if you find Windsor to be negligent and or West End. You would find the percentage of fault attributable to Windsor when compared to the fault of Michael Barrett. The total amount of damage suffered by the plaintiff. Now, you heard much to do about the amount sued in this case. That is not binding on you. That's just an amount. You will decide how much damage has been done in this case, maybe including all the parties involved, singly, even Mr. Barrett. You understand that? The term preponderance of evidence means that amount of evidence that causes you to conclude that an allegation is probably true. To prove an allegation by a preponderance of the evidence, a party must convince you that the allegation is more likely true than not true. If the evidence on a particular issue appears to be equally balanced, that issue has not been proven by a preponderance of the evidence, and the party having the burden of proving that issue has failed. You must consider all the evidence on each issue. Now, negligence is a failure to use ordinary or reasonable care. It's either doing something that a reasonably careful person would not do, or the failure to do something that a reasonably careful person would do, in all the circumstances in this case. The mere happening of an injury or accident does not, in and of itself, prove negligence. A person may assume that every other person will use reasonable care unless a reasonably careful person has cause for thinking otherwise. Now, what are the duties of innkeepers? Generally, one who owns, occupies, or leases property is under a duty to use ordinary care, which is the care that ordinarily careful persons would use to avoid injury to themselves or others under the same or similar circumstances. There is no duty to guarantee the safety of those entering upon the property You should consider all the surrounding circumstances in deciding whether the defendant used such care. A duty of care on behalf of the premises owner to protect plaintiff against criminal acts of third parties arises only if plaintiff can show that the premises owner knew or had reason to know, either from what has been or should have been observed from past experience, that criminal acts against the customers on his premises was reasonably foreseeable. If the injury that occurred could not have been reasonably foreseen, a duty of care does not arise even if the act of the defendant was also a cause of the injury of the injury. A plaintiff must show that the injury was a reasonably foreseeable probability, not just a remote possibility, and that the same action within the defendant's power was more probable than not would have prevented the injury. The general rule of law governing the liability of an innkeeper is that he is not an insurer of the person of his guest against injury. The measure of liability of the hotel to invitees is due care under all the circumstances, including the nature and use of the hotel, the nature of the invitation, the nature of the relationship with the invitee, the opportunity of the possessor and the invitee to know and avoid existing or probable dangers, and any and all other factors which would challenge the attention of the possessor and or invitee to the probability of dangers of the invitees and produce the precautions which a reasonably prudent person would instigate under the same or similar circumstances. The duty placed on innkeepers to protect against registered guests from misconduct of third persons is a duty of care under all the circumstances. The reasonable person standard is in the standard that applies to innkeepers in the protection of their guests. You must also consider whether the hotel was reasonable in the manner in which they dealt with Mr. Barrett and their conduct towards the plaintiff, Ms. Andrews. Now, you're the finders of fact. You have to determine what, if any, protective measures should have been employed by a reasonably prudent hotel operator under the same and similar circumstances. Some of the factors you may consider are whether the hotel is advertised as an unusual establishment which offers better than ordinary facilities, whether the location of the hotel is such to be convenient to criminals, whether the criminal acts have occurred on the premises in the past, but this list is not exhaustive. You must also consider the cost of various protective measures weighed against the expected benefits of these measures, the ability of the guest to protect him or herself by employment of available and relatively inexpensive protective measures, compliance with industry standards, if standards regarding inspections, check-in procedures, and safeguards exist and are found to be reasonable. Now, cause of injury is not a legal cause when there is a superseding cause. For a cause to be a superseding cause, all the following elements must be present. One, the harmful effects of the superseding cause must have occurred after the original negligence. The superseding cause must not have been brought about by the original negligence. 3, the superseding cause must actively work to bring about a result which would not have followed from the original negligence. And 4, the superseding cause must not have been reasonably foreseeable by the original negligent party. Now, the plaintiff must show that the injury was reasonably foreseeable, not just a remote possibility, and that some action within the defendant's power more probably not would have prevented the injury. Foreseeability must be determined as at the time of the acts or omissions claimed to be negligence. Negligence has been defined as a conduct which fails below the standard established by the law for the protection of others against unreasonable risk of harm. The idea of risk in this context necessarily involves a recognizable danger based upon some knowledge of the existing facts and some reasonable belief that harm might possibly follow. Risk for this purpose may then be defined as a danger which is apparent or should have been apparent to one in possession of the actor, in this case the innkeeper. The actor's conduct must be judged in light of the possibilities apparent to it at the time, and not by looking backward with the wisdom born of the event. The standard is one of conduct rather than consequences. It's not enough that everyone can see that the risk was great. If it was not apparent when the conduct occurred. When an injury is not foreseeable, a criminal act by a third person constitutes a superseding, intervening cause of harm, relieving the defendant of liability. The law does not place the onerous duty upon a party of anticipating the criminal act of another unless they arise naturally and spontaneously from the act of that party. As I told you, this is a comparative comparative fault state in Tennessee, and you can compare the fault of one or more persons who may have been at fault. So in deciding this case, you must determine the fault of any of each of the defendants. If you find more than one of the parties at fault, then you will compare the fault of the parties. I'll stop here and tell you that if you've answered the first question, the relationship between Windsor and West End, they should be treated as one for the purpose of this charge. If you find that West End was not the principal of Windsor, then you're talking about Windsor. You understand that? To this, you will need to know the definition of fault. Fault in this case rests upon negligence and negligent infliction of emotional distress. There are remaining issues for you to decide. For the purpose of this instruction, it may help you to understand the definition of fault. A person is at fault if you find that that party was negligent and that the negligence was the cause in fact and legal cause of the injury or damage for which a claim is made. Fault has two parts, negligence and causation. Negligence is a failure to use reasonable care. It is either doing something that a reasonably careful person would not do or the failure to do something a reasonably careful person would do under circumstances similar to those shown by the evidence. The second part of fault is causation. Causation has two components, causation in fact and legal cause. A cause in fact of the plaintiff's injury is a cause which directly contributed to the plaintiff's injury, and without which the injury would not have occurred. To be a cause in fact, it is not necessary that a negligent act or omission be the sole cause of the plaintiff's injury, only that it be a cause. Once you've determined that a party's negligence was the cause in fact of a plaintiff's injury, the next question you must decide is whether the party's negligence was also a legal cause of the plaintiff's injury. Two requirements must be made to determine whether a party's negligent acts or omissions was a legal cause of an injury or damage. One, the conduct must have been a substantial factor in bringing about the harm being complained of. And two, the harm giving rise to the action could have been reasonably foreseen or anticipated by a person of ordinary intelligence and prudence. To be a legal cause of an injury, there's no requirement that the cause be the only cause, the last act or the one nearest to the injury, so long as it was a substantial factor in producing the injury or damage. The foreseeability requirement does not require that the person guilty of negligence to foresee the exact manner in which the injury takes place or the exact person who would be injured. It is enough that the person guilty of negligence could foresee, and through the use of reasonable care should have foreseen, the general manner in which the injury or damage occurred. A single injury may be caused by the negligent acts or omissions of more than one person. If you find that a party was negligent and that negligence was the cause in fact, and also a legal cause of the injury or damage for which a claim was made, you have found that party to be at fault. The plaintiff has a burden to prove the defendant's fault in this case. If the plaintiff fails to do so, you should find no fault on part of the defendant. And that would include Windsor and West End, depending on how you find the agency principal relationship in this case. Now, you found Michael Barrett to be at fault. But if you find both Michael Barrett and Windsor Capital to be at fault, you must then determine the percentage of fault chargeable with each of them. You must determine the amount of damages sustained by the plaintiff. I will instruct you on the law of damages in a few minutes. It is my responsibility under the law of Tennessee to reduce the amount of damages that you assess against any party by the percentage of fault opinion that you assign to that party. The percentage of fault assigned to Michael Barrett and Windsor Capital Group depends upon all the circumstances in the case. The conduct of each may make them more or less at fault, dependent upon all the circumstances. In order to assist you in making this decision, you may consider the following factors, and you may also consider any factors that you, the jury, find to be important. under the facts and circumstances. But the determination of fault on the part of any person and the determination of the relative percentage of fault of any are matters for you alone to decide. As between Michael Barrett and Windsor Capital Group, you may consider: 1, whose conduct more directly caused the injury to the plaintiff; 2, how reasonable was the person's conduct in confronting the risk. For example, did the person know the risk, or should the person have known of it? 3, did the person fail to reasonably use an existing opportunity to avoid an injury to another? Now, this ought to be easy for the 7 women on the jury as opposed to men, but I'll try to describe this in terms of a pie. The percentage figure for each party must range from 0 to 100%. When the percentage of fault of all defendants are added together, the total must equal 100%. So you may know how to cut a pie. Okay. The total percentage cannot be more or less than 100%. The parties to whom you may assign fault are Michael Barrett and Windsor Capital Group. Your next obligation is to determine the full amount of damages, if any, sustained by the following parties without considering the question of fault. And that's Erin Andrews. Now, they have sued for negligent infliction of emotional distress. To recover from negligent infliction of emotional distress, plaintiff must prove the following: 1, that the defendant was negligent, and that the negligence caused a serious mental injury to the plaintiff. A mental injury is serious if it causes a significant impairment to the daily life of a normally constituted person. The mental injury must be established by expert medical or scientific proof. In this case, the plaintiff, Erin Andrews, has asserted the following claims for emotional distress. To recover damages for emotional distress in this case, the plaintiff must prove that she suffered a serious mental injury. A mental injury is serious if it causes a significant impairment to the daily life of a normally constituted person. In determining whether the plaintiff has established the element of serious mental injury, you may consider the following non-exclusive factors to inform your analysis. 1, evidence of physiological manifestations of emotional distress, including but not limited to nausea, vomiting, headaches, severe weight loss or gain, and the like. 2, evidence of psychological manifestations of emotional distress, including but not limited to sleeplessness, depression, anxiety, crying spells or emotional outbursts, nightmares, and unpleasant mental reactions such as fright, horror, grief, shame, humiliation, embarrassment, anger, chagrin, disappointment, and worry. 3, evidence that the plaintiff sought medical treatment, was diagnosed with a medical or psychiatric disorder, such as an adjustment disorder, post-traumatic stress disorder, clinical depression, traumatically induced neurosis or psychosis or phobia. 4, evidence regarding the duration and intensity of the claimant's physiological symptoms, psychological symptoms, and medical treatment. Other evidence that the defendant's conduct caused the plaintiff to suffer significant impairment to her daily life and functioning. In certain instances, the extreme and outrageous character of the defendant's conduct is important evidence as a basis for serious mental injury. Now, if under my instructions you find that the plaintiff is entitled to damages, then you must award her damages that will reasonably compensate her for the claimed loss of harm, which has been proven by preponderance of the evidence, provided you also find that it was or will be suffered by her and was legally caused by the act or omission and condition upon which you base your liability. Mental suffering is a reasonable compensation for any mental discomfort suffered by the plaintiff. Mental suffering includes anguish, grief, shame, or worry. A plaintiff is entitled to recover for this loss if the plaintiff proves by preponderance of the evidence that it is caused by the defendant's fault. No definite standard or method of calculation is prescribed by law by which you to fix reasonable compensation for the damage that she has incurred and has proved. Nor is the opinion of any witness required as the amount of such reasonable compensation. In making an award, you shall exercise your authority with calm and reasonable judgment, and the damage you fix shall be just and reasonable in light of the evidence. Now, as I said, the plaintiff claims damages for serious or severe emotional injury. A A serious or severe emotional injury occurs when a reasonable person normally constituted would have been able to adequately cope with the mental stress caused and brought by the circumstances of this case. Such serious or severe emotional injury must be supported by expert medical and scientific proof. There's no method, as I said, no mathematical formula. In making such an award for damages, you must use your judgment and establish an amount of damage that is fair and reasonable in light of the evidence before you. Now, you are to determine a party's damages. If you determine a party's damages, you must compensate her for loss of harm that's reasonably certain to be suffered in the future as a result of the injury in question. You may not include speculative damages, which is compensation for future loss of harm. Although possible, it's conjectural and not reasonably certain. Now, a person who has been injured has a duty to mitigate damages by using reasonable diligence in caring for an injury and employing reasonable means to accomplish healing. When one does not use reasonable diligence to care for injuries, and they're aggravated as a result of such failure, the damages you shall determine must be limited in the amount of damages that you would have suffered had the injured person used the diligence required. The mere fact that a competent physician advised an injured person to submit to a course of treatment or surgery does not require you to conclude that that injured person was negligent or unreasonable in declining in treatment or surgery. Other factors confronting the injured person must be considered in determining whether, although refusing to follow the physician's advice, the person nevertheless used reasonable diligence in caring for her own injuries. Now, you've heard life expectancy read to you. The life expectancy that was read to you is not conclusive, but is an average life expectancy of persons who have reached that age. You should be aware that many persons live longer, many die sooner than the average. This figure may be considered by you in connection with other evidence related to the probable life expectancy of the plaintiff, including evidence of the plaintiff's health, occupation, habits, and other activities. Now, the remainder of the instructions will be given to you after the lawyers argue the case to you, relating to your duties as jurors in reaching a verdict. Suffice it to say that the jury system is the best system in America, and it's a whole lot better when jurors can come up with a verdict, and I'll charge you that later on. At this time, we'll take a lunch break. When you come back in 30 minutes, we have actual lunch provided for you in the jury room, so we'll go about 30 to 40 minutes, at which time the attorneys will begin their arguments to you. You may be excused.
All right.
The court's instructions on any subject, including instructions on damages, must not be taken by you to indicate the court's opinion of the facts that you should find or the verdict that you should return. And all the parties in this courtroom want you to return a verdict. Now, how do you do that? Your attitude and conduct at the beginning of your deliberations are very important. It is rarely productive for any juror to immediately announce a determination to hold firm for a certain verdict before any deliberations or discussions take place. Taking that position may make it difficult for you to consider the opinions of your fellow jurors or change your mind, even if you later decide that you might be wrong. Please remember that you're not advocates for one party or the other party. You are the judges of the facts in this case. Each of you should deliberate and vote on each issue to be decided. Before you return a verdict, however, each of you must agree on the verdict so that each of you will be able to state truthfully that the verdict is yours. As I told you, the question of whether or not these parties were principal agent can be decided by all of you, or can be not decided by all of you, so you still have to go to the second question. You understand that? Now, the verdict you return to the court must represent the considered judgment of each of you. In order to return a verdict, it is necessary that each of you agree to the verdict. Your verdict must be unanimous. That is to the second part, as I just mentioned to you. It does not need to be unanimous as to the principal agent issue in this case, but the other part of this case has to be unanimous. It is your duty to consult with one another and to reach a verdict if you can do so without violating your individual judgment. Each of you must decide the case yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and to change your opinion if you're convinced that it is not correct. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of reaching a verdict. Now, the law forbids you to determine any issue in this case by chance. If you decide that the plaintiff is entitled to cover damages, you must not arrive at the amount of those damages by agreeing in advance to use each juror's independent estimate of the amount to be awarded, to total those, to divide by 12, making the resultant average the amount you award. Now, if a question arises during the deliberations and you need further instructions, please print your question on a sheet of paper, knock on the door, and I'll have a court officer sitting outside, or you can call on the telephone. I will read your question and I may call you back in the courtroom to try to help you. Please understand that I may only answer questions about the law and cannot answer questions about the evidence. Now, I remind you that you decide this case based solely on the evidence you've heard in this court. You are prohibited from considering any other information, and you are not to consult with any outside sources of information. You must not communicate with or provide any information, photographs or video to anyone by any means about this case or your deliberations. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, computer, the internet, any text, instant messaging service, or any chat room, blog, websites such as Facebook, MySpace, LinkedIn, YouTube, or Twitter to communicate with anyone or to conduct any research in this case. Now, when you come back to this court with your verdict, it'll be put in this form, put in this envelope by the person you choose as foreman. After your verdict comes back, you may be polled. Each side has a right to poll you to make sure that that's your verdict. You'll be polled by your names, and I need to tell you, since you won't be blindsided, that your names will be public record after the case is over. Now, you will retire now and select one of your presiding juror to be your deliberations. As soon as all of you have agreed upon a verdict, the presiding juror will complete and sign the verdict form, and you will return that to this room. You may deliberate only when all of you are present in the jury room. You may not resume your deliberations after any breaks until all of you have returned to the jury room. The verdict form will be given along with the charges. You will be provided lunch. So at some point, the poor person notifies us that you're ready for lunch. We'll have lunch for you. At this time, you may be excused to start your deliberations. Well, the first thing is I want to take this opportunity, because I probably won't see you again, to thank you for your service. You've been very attentive and very conscientious. Thank you very much. We've left you certificates in your seats. I'm sure this is a case that you will remember the rest of your lives. Now, you've given a verdict in this case, and let me go over this with you. After I read the verdict, the attorneys may ask that you be polled, which I'll do that to make sure that each of you say it's your verdict. After that, I'll offer to the parties, starting with Ms. Andrews, that she can leave through these doors here, and she wants to do that. Now, to offer the same thing to the representative. Is there a representative? They're gone. I don't hear one right here. You can go. I ask you to keep your seats until all that's done. Then you're excused, and so being excused, you can talk to the lawyers, you can talk to the news media, you can talk to anyone you want to, your wives, your kids. You'll be excused from jury duty now. It's your privilege not to talk to anybody. If you wish to go through the back passage, please signify, and we'll take you back this way too. Does everybody understand all that? Yep. Okay, I'll read the verdict then. Erin Andrews versus West End Hotel Partners, doing business as Nashville Marriott at Vanderbilt University, and Windsor Capital Group Incorporated as defendants, as well as Michael David Barrett. Question number one. We, the jury, answered the following question: was the defendant Michael David Barrett at fault? Answer: yes. Question number two. Did the defendant Windsor Capital Incorporated to be at fault? Answer: 12 yes. All unanimous. Is that correct?
Correct.
Question number three. Do you find that Windsor Capital was the agent of West End Hotel Partners Incorporated? Do you find yes? 12-0. All of you say that?
Yes.
Question number four. Defendant Michael Barrett is at fault. Did you find Windsor Capital Group to be also at fault in this case? Also West End. What is the percentage? The total percentage of defendants you find to be at fault must equal to 100%. You find that Windsor Capital was 49% at fault, and that Michael David Barrett was 51% at fault. Correct?
Correct.
What amount of damages, if any, do you award the plaintiff, Erin Andrews? $55 million, correct?
Yes.
Okay, extrapolated, that turns out to be a judgment against Mr. Barrett for $28,005,000, $28,500,000. Against Windsor Capital, $26,750,000. All of you say that?
Yes.
Correct. Would you like the jury poll defendants?
Yes.
I read your name. If you so find, please say I do. Noble Taylor?
I do.
Terry Applegate?
I do.
Tammy Kump?
I do.
Susan Campbell?
I do.
Chad Doran?
I do.
Carolyn Sadler?
I do.
Jeffrey Lowe? I do. Alyssa? Okay, you can come back this way.
And she'll stay, Your Honor.
Huh?
She'll stay.
Okay, now you can talk to the lawyers here. Ladies and gentlemen of the jury, you can talk to Ms. Andrews. The partition here will keep everybody, the news media from coming in that part. Whether you want to go back here later, if knocking on the door, we'll let you go back later. How about the representatives? Do y'all want to go out this way? Okay. Okay, the court's in recess. You may step down and talk to me if you want to.
All right.
Your Honor, we have, now that trial is over, that the cameras be turned off. We certainly don't want the media taking video if we speak with the jurors or if Ms. Andrews speaks with the jurors.
Okay, I will order that.
Thank you, Your Honor.
But they're not turned off outside the courtroom. Only in the courtroom. Okay?
Thank you, Your Honor.
Okay.